Panagdahit sa Diyos, sa tanan manis na Kachin Fortes, and I'll be reporting the article 1209, joint and solidary. So these articles speaks of the joint and joint indivisible obligations. So if the division is impossible, the right of the creditors may be prejudiced only by the collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the other shall not be liable for his share. So it is joint as to the liability of the debtors on the rights of the creditor, but indivisible siya as to compliance. So, kuan siya kanang, in the sense nga, kuan bitaw, it can only be applied all at once. Dili siya partially performed, dili siya tegi-tegi. Kanang all at once na jud siya all together. So, this obligation constitutes the middle ground between the joint indivisible obligation, the joint obligation, and the solidary obligation. So when I say joint indivisible obligation, man siya, not synonymous ni siya. And solidary obligation kay a joint indivisible obligation pod. So it is joined in the sense nga each of the joint debtors kay liable siya proportionately sa ilahang mga shares. And then dili katong para kung yung gina nga dili siya tegi-tegi all at once yun siya kanang kung unsa ang nasa pikas kay joint magod, kung unsa pod ang makuha sa isa kung unsa ang kailangan ikumpay sa isa dapat pikas pod. So while kaning prestation may not be performed partially good, so it can only be performed all at once. So example, si Carlo og si Mark, si Mark kay kuan siya, jointly liable siya nga muhatag og car kang Carlo valued at 5 million pesos. Yes. So ang date sa delivery ni Mark kay si Mark atong sa katong date na gid sa delivery kay si Mark willing na siya mo deliver sa car. Pero si Carlo dili siya, since the car is indivisible man. So the debt can only be enforced by proceeding against all the debtors for the compliance. So dili siya pwede ma-comply unless kay tanan sila. Kay si Carlo dili man ready si Carlo. So si Mark raman, so dili gyapon siya pwede. So dili siya ma-comply kay sa ilang obligation man god, since ang sakinan kay indivisible siya. So in this case, the liability is converted in the form of damages. So there are characteristics of a joint indivisible obligation. So first is the obligation is joint, but since the object is indivisible, ang creditor daw must proceed against all the joint debtors would act together. Kay joint gali, dili jud isa-isa, dili tegi-tegi para sa example ganina. And then the demand must therefore be made on all the joint debtors. So dapat giagrihan gyud to siya sa tanan. So if there are made joint creditors, delivery must made to all and not merely to one. So if nga daw nga gibuhat katubitaw ganina nga, the demand must therefore be made. Pag nana sila demand gagibuhat sa joint creditors, kay ang delivery daw dapat sa tanan, dili lang daw sa isa-isa, not merely to one, unless daw o specifically jud siya nga gi-authorize siya sa kanang sa tanan bitaw nga ilahang kauban, like kanang it is not merely to one, unless that one be specifically authorized by the others. Kay kuan man sila kanang tanan bitaw group ni sila. Dili siya pwedeng isa-isa tegi-tegi og isa lang imo tagaan na bitaw. Joint creditors is allowed to renounce his proportionate credit. So pwede niya yang kuwaon ang iyahang share. And then if there are made joint creditors, so dili gid siya pwede og isa-isa kay kuan na gali kanang iba-iba maguna sila og share, kanang iba-iba ni sila og share bitaw daghan ni sila nga gi-join tas kanang iba-iba sila og share, dili pwede tegi-tegi isa lang ang mo-comply, dapat tanan. That's all. Thank you. Bye.
Panagdaig sa tanan, my name is Jessel Samantesa, and my article found on 1210, it says the indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity itself imply indivisibility. So this article presents the dichotomy between the indivisibility and solidarity of obligation. So meaning to say, this provision talks about the indivisibility, tapos distinguish niya kay solidarity. Sabi, ang indivisibility ng obligation ay hindi kaagad nangangahulugang solidarity. At porket hindi indivisible ang object ay solidary na. Same rule din naman kapag baliktad. Ang solidarity ng obligation does not itself imply indivisibility. So when you say solidarity, it implies, it connotes, it pertains to the obligation of the debtors, whether the debtors can be held liable to the entire obligation. So that is solidarity. Now, when we say indivisibility, this pertains the obligation can be performed or not. So if you are asked to distinguish between the divisibility or solidarity, so divisible obligation, only the debtor guilty of the obligation is liable for damages. While in solidary obligation, all of the debtors are liable for the breach of obligations committed by a debtor. So, take note of this important distinction. When the debtor is guilty of the breach of the obligation, for example, the debtor did not comply with his own part of the contract. So, what is the effect of that? And are the other debtor or are the other innocent debtor, I should say, liable for the payment of damages? So, it depends, no? In case that the obligation is indivisible, only guilty debtor is guilty. I mean, only the guilty debtor is liable for damage. On the other hand, if the obligation is solidary and one of the solidary debtors is guilty for the violation of the contract, then all of the solidary debtors is liable for the payment of damages, since solidary among them remains of the breach. So in case of indivisibility, only the guilty debtors liable for the damages. On the other hand, in solidarity obligation, all of the solidary debtors, including those innocent, solidary debtors can be held liable for the payment of damages. Indivisibility can exist although there is only one debtor and one creditor, while in solidarity, there must be two debtors and two creditors. In indivisible obligation, others are not liable in case of insolvency of one debtor. While in solidary obligation, others are proportionately liable for the or proportionately liable. Example of indivisibility. If the obligation is to deliver a racing horse. Now, if the obligation constitutes the delivery of a racing horse or a racehorse, then there can be only one debtor, but you cannot deliver the horse in parts. Otherwise, it will be no longer of use to the obligee. That's what you mean in divisibility, where there must be one creditor and one debtor. While in solidarity, there must be at least two debtors and two creditors. Okay? Because it pertains to juridical tie or juridical relation of the parties. So take note of this. In indivisible obligation, the others are not liable in case of insolvency of one debtor. While in solidarity obligation, the others are proportionately liable of the obligation. So the first sentence in Article 1210 simply means that the liability in an indivisible obligation may be either be joint or solidary. The second sentence means in an solidary obligation, the subject matter may be divisible or indivisible. So that would be all. Thank you.
Good day everyone, my name is Adeline Gumisad and I'm going to discuss the Article 1211. So Article 1211 states that the solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same period and condition. So there are two kinds of solidarity obligation under the legal ties, which is the uniform and non-uniform or varied. When we say uniform, it is when parties are bound by the same stipulation, and non-uniform or varied naman, it is when the parties are not subject with the same stipulation, or it is when they debtor, while bound under the same obligation, are not subject by the same terms and condition of payment, but to the different secondary stipulation or clauses. I have here the example. So this is the example. Needs Daisy and June obtained a 900,000 pesos loan to Digna, which they executed a promissory note solidarily binding themselves to pay Digna under the following term. So Needs will pay 300,000 pesos with 12 interest on January 13, 2016. Daisy will pay 300,000 pesos also with 12% interest on February 13, 2016, and June will pay 300,000 pesos with 12% interest on March 13, 2016. So when January 13, 2016 comes, Daisy can collect 300,000 pesos with 12% interest from either Needs, Daisy, or June, but she cannot collect the whole amount because it is not yet due. Though si Needs siya ang naka-assign na mabayad ng 300,000 on January 13, 2016, but because it is solidarity obligation, pwede siya makapaningil kay Needs, Daisy, og June. So the creditor must wait until the maturity of other amounts. She can still collect the amount in either of them when the next maturity comes because the tie of the solidarity among the debtors is preserved and not affected by the difference of the secondary terms and stipulation assumed. So, pag abot sa February 13, 2016, makakollect siya sa other 300,000 with 12% interest from either Needs, Daisy, and June. Kaya again, it's solidarity obligation man siya. So what if June will pay the 300,000 pesos with 12% interest if he passes the board exam? So Digna can collect the 300,000 pesos with 12% interest if June fulfill the condition, which is to pass the board exam. But still, Digna can collect the remaining 300,000 pesos on either needs Daisy and June because again it is solidarity obligation. Thank you for listening.
I am Junide Jency Claret, and I will tackle about Article 12. So Article 12, each one of the solidary creditor may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. So it means that solidary creditor may perform acts that will benefit each other, but if one of them performs an act which is prejudicial to the others, like having bad effects, the performing creditor will be liable to his co-creditors. The acts of one will affects the other because of their relationship, just like the theory of mutual agency. So there are two acts, which is acts beneficial and acts prejudicial. So acts beneficial is all creditor may perform acts that will benefit each other. They may help each other to have more gains and build up the relationship in good standing. So for example, Anna borrowed money from Rutland and Danica amounting 10,000 pesos. So in such case, when the debt becomes due and demandable, either Rutland or Danica may make judicial or extrajudicial demand for Anna. So for payment of Anna will rebound to the benefits of Rutland and Danica. So acts of prejudicial. If one or more of the member performs acts that will have bad effects, loss of profit or may harm the good standing, in which the performing creditor will be liable to his co-creditors. For example, it's when Joy is in debt to both Jen and Rose, the amount of 20,000 pesos. So Jane cannot renounce the debt of Joy and inform her that she does not need to pay the debt because it is prejudicial to interest of the other solidary creditor. So if Joy does, she be solely liable to Bunch for the latter share of credit. That's all. Thank you.
Panagdait sa tanan. So, I am Zaliboy the second under this panel, BSIS 2. My assigned task is to report the Article 1213. Article 1213 says that a solitary creditor cannot assign his right without the consent of the others. And this article means that a solidary creditor cannot give his right or assign his right to a third person. For example, I am in a group po ng nagpapautang. So, di ko pwedeng ibigay ang aking karapatan sa iba nang walang pahintulot ng aking mga kasama. Dahil kapag ang karapatang nabigay sa iba na walang pahintulot ng aking mga kasamahan, ito ay walang bisa. Natin na si A ay may utang to solidary creditors B and C. So C ay hindi niya pwede i-assign ang kanyang karapatan to D without the consent of D. The reason is the extraordinary mutual trust and the confidence among the solidary creditors, and it may happen that the other creditor may not want dealing with the person to whom that debts will be assigned. So other example is Mr. A may utang kay solitary creditor B and C. So hindi inaasahang pangyayari, si C ay may pinuntahan sa abroad para sa business transaction. So pagbalagay natin na ako si B. So without the consent or the permission of Mr. C, I nagdemand ako nagbayad sa nangungutang. So the demand is valid ba? So yes, it is valid because under Article 1213 that if the assignment is made by co-creditor, the consent of the other creditors is not necessary. And we always remember that Article 1213 as a solidary creditor cannot assign his right without the consent of the others. And also we should remember that under Article 1213, if the assignment is made to a co-creditor, the consent of the other creditors is not necessary. Thank you.
Hello everyone, I am J. Lester S. Baltasar. I'm the one who will report the Article 1214. The debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. So, in the Article 1214, answers the questions to whom would the debtor will pay. So, nakabutang diri nga the debtor can pay any of the solidary creditors. Solidary creditors means all for one for all. So, bisag kinsa daw sa solidary creditors, pwede mubayad si debtor. Pero naa siya'y exceptions. Kung naay mo demand sa creditors. If someone's demand daw, judicial or extrajudicial, kung kinsa ning demand, payment should be made to him daw, to the creditors who demand. For example, Bong, Kikos, and Daisy are solidary debtors of Mike and Marcos, solidary creditors for 100,000. Mike makes a demand to Kikos. So the question is, to whom should Kikos pay? So, klaro kayo nga si Mike ang makadawat. Kay siya man ang ning demand. Sige, ibutang nato nga si Mike ning demand, tapos ang gibayaran ni Kikos kay si Marcos. Pwede ba na siya? Madawat ba siya or ma-extinguish ba na siya? Syempre, dili. Kay klaro kayo sa law nga kung kinsa tong ning demand, mo siya'y dapat makadawat sa payment or bayad. That's all for Article 1214 and thank you.
Good day, my name is Adil A. Sukador. I will now be discussing the next articles, Articles 1215 and Article 1216. Article 1215, first paragraph, innovation, compensation, confusion, and remission of debt made by any of the solidary creditors or with any of the solidary debtors shall extinguish the obligation without prejudice to the provisions of Article 1219. So the first paragraph states that obligation will extinguish if any of the solidary debtors or creditors executed any of the acts. So here's a general view of the acts that will extinguish the obligation. Here are the modes and causes of extinguishment of obligations. First, we have this novation. Novation is when obligations are modified by changing the object or the principal condition, or by substituting another in place of the debtor, or by subrogating a third person in the rights of the creditor. So innovation, this pertains to the changes in the obligation. It could either be that the object of the obligation or the creditor or the debtor that has been substituted. This is like the creation. Innovation is the creation of a new obligation in substitute of the obligation that was agreed. Next, we have this compensation. Compensation is when two persons in their own right become creditors and debtors of each other. So in compensation, you will find that the two persons have become the creditors and debtors, in which the two persons are liable to the other. For example is A is liable to Z in paying 5,000 pesos. And an example is Z borrowed the same amount from A. You can see that both A and Z have become both the creditor and the debtor, in which two debts are present in the obligation. Next we have is confusion. Confusion when the characters of creditor and debtor are merged in the same person. That in obligation, you may find that one of the persons will become both the creditor and the debtor, in which the person owes himself in the obligation on how he is not to on how he is liable to the other, and how he is able to receive the same thing, in which he is now become both the creditor and the debtor. Next we have is remission. Remission, this is the greatest abandonment by the creditor of his right. In this, the creditor has the right to cancel the obligation in favoritism to the debtor, or in other reasons. The example is A owes Z 10,000 pesos, but then Z tells X to forget or cancel in giving him the amount. This pertains to the examiners of the obligation, which is remission. Next paragraph of the Article 1215, the second paragraph states that the creditor who may have executed any of these acts, as well as who collects the debt, shall be liable to the others for the share in the obligation corresponding to them. This pertains to the part of the creditor, that if he is able to execute one of the most of the distinguishment, or the creditor collected the debt from one of the solidary debtors, he is liable to pay the other solidary creditors in their share of the obligation. Here we have the examples of the first and second paragraph of Article 1215. Here we have the first paragraph example. Solidary debtors M and A are liable to pay S 10,000. However, S borrowed A the same amount, making him liable to A. In this, we can see that S and A are compensated with each other, in which through this, since compensation is present, this will extinguish the obligation, as well as it will extinguish M's obligation to pay S 10,000 pesos, since it is now focused on S and A who are indebted to each other. Now another example is in the second paragraph is M owes L and A, the creditors, an amount of 10,000 pesos. So if L collected the debt, of course, he is liable to pay L for his share in the obligation, which is 4,000 pesos, which is stated in the article. That if one of the creditors collected the debt, he is liable to pay the other solidary creditors for their share in the obligations. Let's go to the next article, Article 1216. In Article 1216, it states the creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them shall not be an obstacle to which may subsequently be directed against the others, so long as the debt has not been fully collected. So in this, the creditor can address to any, some, or all of the one of the solidary debtors in demand to pay for the obligation. So for example, if the solidary debtor was to proceed from one of the solidary debtors, and the solidary debtor cannot pay, then the creditor can still go to one of the solidary debtors to pay for the balance, as long as it is not yet the entire obligation, in which he may go to the others until the obligation is fully satisfied. Next, let's go to an example of this Article 1216. Example is A, B, and C are liable to pay the 12,000 pesos. D proceeds to be a solidary debtor and collected 5,000 pesos. So, can D still sue A and C for the remaining amounts? The answer is yes, because since D collected from B the amount of 5,000 pesos, the obligation has not yet complete, and since the debt has not yet entirely completed, D can collect from A and C or any one of the solidary debtors to pay for the balance, which will fully satisfy the obligation. And that is for the Article 1216.
Panagdait everyone, my name is Carlo B. Gagampang, and I will going to discuss Article 1217 and Article 1218 under Section 4, Joint and Solidary Obligations. Without further much ado, let us start. Article 1217. Payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. He who made the payment may claim from his co-debtors only the share which corresponds to each, with interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. Now, I think the first paragraph of this article is self-explanatory. It says, payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. Meaning, dito si creditor may choose or he has an option kung sino sa kanila o sa kaninong offer ang tatanggapin niya. In order to understand this, let's first have an example. Frodo and Sam are solidary debtors of Gandalf to an amount of 100,000 pesos. So, dito, Frodo and Sam offered to pay Gandalf. So, Gandalf now has an option or he has a right to choose as to whose payment ang tatanggapin niya. It's either kay Frodo or kay Sam. Now, suppose si Frodo, he paid the whole amount of 100,000 pesos. So, si Frodo ngayon ay pwedeng mag-ask ng reimbursement from Sam plus interest. That is according to the second paragraph of this article. Sabi pa nga, if paid after maturity, interest shall run from the date of payment until reimbursement is made. And if paid before maturity, interest shall run from maturity until reimbursement is made. In our example, between Frodo and Sam, if Frodo paid on due date, he can ask reimbursement from Sam without interest. However, if si Sam ay nagbayad lang kay Frodo or nag-reimburse lang siya kay Frodo after 1 year from the date noong nagbayad si Frodo, then Sam needs to pay an interest from the due date up to the time na nagbayad siya ng reimbursement. Now, suppose, pagpalagay natin, before maturity, nagbayad si Frodo kay Gandalf, let's say 1 month before pa ng maturity ng utang. For example, nagbayad siya ng November. Kahit yung maturity talaga ng utang is December pa. So, question, can Frodo collect from Sam an interest from November? The answer is no. Kasi hindi pa naman due date at that time. No? Hindi pa due at that time. At sa December pa talaga mag-start yung interest. Okay? Now, the last paragraph of this article states that when one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. Now, for our broader understanding regarding the last paragraph of this article, Let's have another example. Jose, Marie, and Chan are solidar debtors of Pedro for an amount of 1 million pesos. Jose paid Pedro the whole amount of 1 million pesos. Now, obviously, no, ang pagbabayad ni Jose kay Pedro, it gives him the right to demand reimbursement from Marie and Chan, each with interest from the date of the payment. Unless si Jose ay hindi naman entitled or he have no right to the reimbursement sa interest for any payment kung nagbayad siya before yung due or maturity ng 1 million pesos. So the obligation of Marie and Chan to reimburse Jose with interest will arise only upon the maturity of that obligation. Now, the last paragraph of this article, no, applies if however after noong nagbayad after noong pagbayad ni Jose, kung si Chan ay naging insolvent. When we say insolvent, wala na siyang kakayahan na magbayad or mag-reimburse kay Jose. And so the last paragraph of this article says that such share shall be borne by all his co-debtors in proportion to the debt of each. Meaning, si Jose and Marie shall bear the insolvency of Chan in proportion to their shares. So si Jose can still ask Marie to pay an additional sum. So yung hihingi ni Jose dito is kay Marie is yung reimbursement ng share ni Chan plus an additional sum which is equivalent to the reimbursement because of the insolvency of Chan. And this is in proportion to the of the share of Jose and Marie. Of course, Jose and Marie can later on recover from Chan kapag nag-improve naman yung financial status or yung finances ni Chan. So that's what Article 12.17 talks about. Now, let's move on to Article 12.18. Article 12.18. Payment by a solidar debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. So this article naman, this discusses the effects, no? The effects of payment when the obligation has prescribed or has become illegal. So again, 'di ba, yung rule is when a solidar debtors pay the obligation, binayaran niya ang obligation as a whole. Sa kanina nga example, Frodo paid the whole amount of 100,000. So 'di ba, he is entitled to reimbursement from his co-debtors. Siyempre, siya lang ang mag-isa nagbayad, so manghihingi talaga siya ngayon ng reimbursement sa mga kapwa niya debtors. Now, Article 12.18 mentions two cases or dalawang scenario kung saan yung debtor, yung paying debtor o yung nagbabayad na debtor cannot get any reimbursement from his co-debtors. Dito, ano yung situation kung saan hindi marireimburse ni paying debtor is first una, when the obligation has prescribed, and second, when the obligation becomes illegal. I mean, pag nangyari itong dalawa, the obligation has prescribed and obligation becomes illegal, tapos nagbayad pa rin si debtor or nag-comply pa rin siya sa kanyang obligation. Now, let's have another example in order to understand this. First, we have an example. Legolas and Gimli solidarily bound themselves to give Aragorn some drugs worth 1 million pesos. Later, a law was passed prohibiting the transactions of said drugs and declares the drugs to be outside of the commerce of man. Knowing this, Legolas still voluntarily delivers the drugs worth 1 million pesos to Aragorn. So in this case, may Legolas gets reimbursement from Gimli sa share ni Gimli sa obligation. Since the rule is when the debtor pay the whole amount, he has a right to collect reimbursement from his co-debtors. So in this example, of course, Legolas cannot get reimbursement from Gimli because Article 12.18 says so. It says, payment made by a solidar debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. So that's what Article 12.18 talks about. So ang rationale lang dito sa Article 12.18 is that yung general rule, di ba, is when the paying debtor paid the whole amount, So he has a right to collect reimbursement from his co-debtors not until when the payment is made after the obligation has prescribed or it becomes illegal. So that's Article 1218 talks about. Thank you once again and panagdait everyone. God bless.